Welcome to the pretrial motion section of Module 6, Trial Execution of the ULB Justice Center website. This section will focus on one specific motion, which is motion in limine. Please be advised that the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you to consult with an attorney. In this section, we'll be discussing where you are in the process, what the purpose of this step is, what you need to do to accomplish during this step, who do you send it to, when do you send it and file it, what is the timeline of, and what is expected to happen next. Where am I in the process? Prior to starting trial, there will be a pretrial conference. The pretrial conference is where the parties and the court lay out the expectations for trial and address any evidential issues. This motion is brought to address evidence that is irrelevant, privileged, confusing, or has any other legal issue. The motion can be done prior or during trial, and verbally or in writing. Preferably, it should be done prior to trial and in writing using pleading paper. However, if the evidence is presented right before trial or during trial, it can be addressed verbally because you do not have enough time to serve them with the motion. What is the purpose of this step? The purpose of this step is to avoid damaging evidence in your case. You want to avoid jurors from unseeing damaging evidence that has already been exposed to them, even when the court tells them to ignore it. The purpose of the motion in limine is to prevent the other party from introducing matters at trial which are irrelevant, inadmissible, or prejudicial to your case. Some key statutes to rely on in excluding those types of evidence from being introduced at trial are Evidence Code 350, 352, and 402. Make sure you look into the most recent update for these evidence codes or any other evidence code that you find so that you can provide accurate information. What do I need to accomplish during this step? During this step, you should write a clear legal argument that supports your conclusion that the evidence should not be allowed at trial. Lay out the evidence you want excluded through 4 steps. Number 1, make it clear who you are. For a verbal example, you can say, "Your Honor, my name is Jane Smith. I am the plaintiff in this matter." Number 2, describe the evidence and why it should be excluded or admitted. Number 3, analyze it. Lay out the case law and court rules to support your argument. Number 4, remember to ask for a remedy. What do you want the judge to do for this motion? For example, if it's a verbal argument, you could say, "Your Honor, based on the information that I provided, you should sustain my motion and exclude the evidence at trial." Your job here is to convince the judge to grant your motion. Who do I send this motion to? After you file your motion with the court, make sure to serve 1 copy to all parties in the case. If it's an individual who is representing themselves, make sure to serve that individual. If it's an attorney that is representing an individual in the case, make sure that you serve the attorney on behalf of their client. Do not serve a copy to an individual if they are already represented by an attorney. And don't forget to keep a copy for yourself. When do I send and file this motion? Well, the timing for the filing and serving of motion in limines are usually left to the discretion of the trial judge. There are statewide rules that dictate the timing when an expedited jury trial is involved. If an expedited jury trial is involved, then the motion in limine must be served on all parties no later than 25 days before trial. Motion in limine are frequently presented in conjunction with a trial brief. If you are filing in opposition to another party's motion in limine, separate points of authorities should be submitted in support of your opposition. The filing of an opposition and reply to an opposition are also set by the trial judge. So speak to your trial judge or their clerk for their requirements and deadlines in filing and serving a motion in limine. How do I send and file this motion? Motions in limine get served and filed as any other legal documents do, unless the court indicates otherwise. There are circumstances in which the court might require that trial documents be delivered directly to the department rather than through the clerk's office. For filing, you will file your motion with a proof of service attached to it. The proof of service can be on pleading paper, or you can choose to use the judicial forms provided to you on the www.courts.ca.gov website. For civil cases, you can use the POS-040 as your proof of service, and if you need additional room to add persons that are being served, you can use the POS-040P. Make sure that you check your court's website for their preferred filing method. For example, Los Angeles County has multiple websites that you can use as they do e-filing. You can use www.californiaefiling.com. For Orange County, they use one specific e-filing method, which is www.orange.efilingportal.com. Since a lot of California has implemented e-filing as their preferred method of filing, just make sure that you check their websites and confirm which method that they prefer. For serving, make sure that you check with your trial judge and their clerk for deadlines. However, documents are usually served by mail or electronic service. The proof of service must state the following: their name of the person being served, the address, email and or fax, and the description, whether they are plaintiff, defendant, if they are attorney for the plaintiff or defendant, and then make sure you add the name of that plaintiff or defendant that they represent. If they are cross-complainant or the cross-defendant, make sure that you add that as well. A plaintiff and cross-defendant, and it might be a defendant and a cross-complainant, so you want to add both. What is the timeline of and what is expected to happen next? Some judges require that the parties file and serve the motion a specific number of days before the trial setting conference. Generally, this is between 5 and 14 days before the pretrial conference. However, you need to check with your court clerk or trial judge. If you file a motion, the opposing party who is wishing to admit this evidence should file an opposition. That opposition is for them to oppose the information that you are wishing to exclude in your motion. If your opposing party files an opposition, then you must file a reply to their opposition. This is your last chance to convey to the judge why the information should be excluded or admitted. Some judges set the deadline for filing motions in limine, oppositions, and reply papers in the final case management conference order. In some courts, filing deadlines are specified by local rules, so make sure that you check your court website for their local rules and local rules. This has been an overview of the pre-trial motion in limine section of the ULV Justice Center website. We thank you for your time and hope the information is useful in your legal matter. Please be advised that the information provided on this site is not for legal advice. It is provided to you for informational purposes only. If you are in need of legal advice, we advise that you consult with an attorney.